Good afternoon, friends. This is in continuation of our special series of GST on summon, inspection, search, seizure, and arrest provision. Under arrest provision, as per section 69 of CGST Act, where Commissioner is having reason to believe that any person who is engaged in four specified offences under section 132 subsection 1 clause A to clause D of CGST Act, Commissioner can order for arrest and he may authorize other officer to arrest such person. So question which was very important and we are discussing, what is the meaning of reason to believe? Whether arrest can be initiated prior to adjudication and assessment, the first point. And second, if arrest is being initiated, what are the important precaution department must adhere to so as that would be called legitimate and legal arrest memo to avoid misuse of illegal arrest. Recently, the Honorable Gujarat High Court, in the case of Bimal Yashwantgiri Goswami case, the judgment and ruling says that this reason to believe which is contemplated for arrest under section 69 read with section 132 of CGST Act, it is subjective determination, and this subjective determination is on the basis of some credential information, some substantive proof in the hands of department which is authorizing them for arrest, and that is called reason to believe, even that such person is not guilty of an offense. Unlike in criminal cases, Code of Criminal Procedure, a police officer has to file, lodge and registered FIR. But in the case of GST, lodging a complaint before the competent court is sufficient enough to move and go ahead for the arrest provision. So concluded that even prior to adjudication and assessment, arrest can be done under GST law. This is the widest meaning coming out. This is the judgment really giving widest power in the hands of department. But this judgment further goes down and relying on Honorable Supreme Court, Apex Court judgment in the case of D.K. Basu versus State of West Bengal, 1997, Volume 1, SCC, page number 419, and said arrest memo is the basis. Department must prepare the arrest memo and show the reason, grounds for arresting such accused person. And this arrest memo should be prepared carefully. All the reasons must be cited, and this should be submitted before the judicial magistrate. Then only arrest can be initiated. And if Honorable Judicial Magistrate is not satisfied with the arrest memo because it is not being prepared in a way required to be, reason not cited, what is the reason for arresting a person, then he may reject that protection of that accused person and he may reject remanding that person as well. So arrest memo is important one, and it is being stated whenever arrest is being made under section 69 read with section 132, it should be used exceptionally and should not be used in vague situation. So whenever accused person who is being alleged engage in four specified offences must be cited with the ground and region. And whenever he is arrested, he must be told for this region he is being arrested and must be produced within 24 hours before the judicial magistrate. This judgment is mainly focusing and also emphasizing the Honorable Apex Court judgment in the case of D.K. Basu and saying what are the do's and don'ts whenever we see the arrest made by the department and they are using the provision of section 69 read with section 132 of CGST Act. On one hand, this judgment is saying that arrest can be initiated even prior to adjudication and assessment. Widest power within the four corners of region to believe. But four corners of region to believe must be ensured with the reliable information in the hands of department so as they are having reason to believe, and arrest memo should be the basis, and to avoid all illegal arrest a proper arrest memo need to be prepared by the department, and that would be the basis for judicial magistrate for remanding the accused person for judicial custody. But we know that reason to believe and prior to adjudication and assessment are subjective issue. I have only cited one recent Gujarat High Court judgment and talked about the relied upon apex court judgment of D.K. Basu. But this issue is very, very important. And it must be whenever a person gets arrested, it must be ensured the fundamental right of such accused persons are not violated. And department must be having some reliable information, some substantive material against that accused person so that they can prove they are having reason to believe for arresting such person. So we have tried our best to give some snapshot that how department can use section 69 read with 132, but taxpayer must take the precaution and they must know what are the four specified offences to take care of their cases, defend themselves. It is for honest taxpayer to fight it out such cases wherever they believe that they are only being alleged with no basis, no reliable information. So we are trying from our side to educate taxpayer and tax consultant with the various and divergent provision of GST. This is the arrest provision and reason to believe. Thanks for watching. Thank you very much.